I want to talk to you today a little bit about the restatement project. And my title today is, Can the Third Restatement Help Untangle Defamation Law's Gordian Knot? And I think you know the legend of the Gordian Knot was, it was a great puzzle. How do I untangle the Gordian Knot? And, the answer is you cut through it. And unfortunately, the answer for defamation law reform is not that we can just cut through it to a simple solution. In this case, it is a very, very complex problem that is going to have to be unraveled thread by thread. And so I want to put you back into thinking about the last restatement, the restatement second. Now, when I started teaching torts when I was 25 years old, I started at the University of Florida teaching torts. And every night I would keep by my bedside this reference book called the Hornbook on Torts. And it was written by a guy named Prosser. And Dean Prosser was a legendary torts figure. To me, he's like, if the god of torts spoke, it would be Dean Prosser. And he worked a long time on the restatement of torts, and then he was succeeded by a man named Dean Wade, who also was a legendary media law scholar. And the ink dried, the last ink on the defamation restatement was dry in 1977. And so I want to put you back in kind of a 1977 mood. Microsoft was 2 years old at the time, Apple was a year old, and Star Wars was in the theater. And I think you will recall that there might have been some changes in the environment surrounding defamation law since 1977. So we have had what is often referred to as the cheap speech revolution. And we all have carrying around in our purses and pockets, all except for my husband, who's in the back, who uses a flip phone. But most of us have massive computing power that we carry around in our handbooks, and we can access a mass audience at any time. And that has had dramatic effects on the news industry, who are some of the repeat players in defamation litigation. So in 1977, they were highly profitable, and they were highly trusted. That's not true today. The competitive environment has changed. I would say that newsrooms have been decimated, but decimated means 10% are gone, and it's really a lot more than 10%. Talent has hemorrhaged out of newsroom, expertise, and the competitive environment for news production is just tremendous. And so you might think that in light of all of this change wrought by the cheap speech revolution, big tech platforms, et cetera, that there would have been a lot of common law reform in defamation law, in the tort of defamation. But the answer is that's not really how it's gone down. And so let me give you a roadmap of what I'm going to say today. I'm going to talk about the reforms that have happened since 1977. Talk about today's critics of defamation law and evaluate their complaints, give an outline for what reform ought to look like, and talk about some of the barriers to the reform, particularly as they relate to the new restatement third. And it really is intimidating. It's a once-in-a-generation project. And this generation in particular, we're at such a pivotal point that we've got to anticipate so many issues going forward to make sure that for the next 45 or 50 years, it doesn't, sound totally obsolete. By the way, we have a draft. The draft is about 100 single-space pages right now. I took out all the references to telegrams. So, true story. Okay, so why is defamation so complex? So one of the things that's being talked about now is New York Times versus Sullivan still good law? Or is it going to be good law when the Supreme Court gets a hold of it? Should it be reformed? But one thing you need to understand that even before the Supreme Court got involved with defamation law and turning it into a constitutionalized tort, defamation law was famously complex. At one point in its history, it was a sin, not kidding, publishable by ecclesiastical courts as long ago as, pre-Middle Ages. Then it became kind of a quasi-tort punishable in manorial courts, and they got into a jurisdictional battle with each other about, okay, you're going to take some kinds of defamation cases, and we'll take these other kinds, the ones that cause temporal as opposed to spiritual harms. And then, if that wasn't good enough, it became a crime, and you have here in the picture the Court of Star Chamber, which becomes relevant because Justice Thomas is now citing this history as being something we should go back to. I wouldn't think Matthew Schaefer was very diplomatic in his piece on the history and the law of scandalum magnatum and the peers of the realm punishing people who criticize them. But I wouldn't think that going back to scandalum magnatum and the criminal law of libel for criticizing famous men would be something we might want to return to. But anyway, I guess you live and learn. So that was 1964. The law was famously complex, and all kinds of scholars had things like, it's filled with anomalies and absurdities, and they had all kinds of aspersions they cast at the tort. And now it's more complex. And why is it more complex? Because it is a Gordian knot of not only tort law, but also constitutional law that sets a floor below which the tort can't go, and statutory law as well. And statutory law on both the federal and state levels. And so if you're going to be involved in defamation law, you've got to have a real sense of all of these things. Now, most of the reforms of defamation law since 1977 have not been common law reforms. They've been constitutional and statutory. And on the constitutional front, we've already talked about it this morning. New York Times versus Sullivan in 1964 was the case in which the Supreme Court said public officials suing for criticisms in their official capacity must prove that those who criticize them knew of some falsity or recklessly disregarded the falsity of what they were saying. And it absolutely revolutionized defamation law. But New York Times versus Sullivan was not the last word. There was a 30-year period after that where the Supreme Court systematically constitutionalized almost every aspect of the tort. Most famously and most relevantly for what we're going to talk about, they expanded the special rule rebalancing cases involving public officials to people that we would today call influencers, public figures. So public figures, if they're going to sue somebody for defaming them, they have to prove that the person knew or recklessly disregarded the falsity of what they were saying, and they also have to prove falsity, which turns out to be a barrier as well. Okay, but the Supreme Court got finished with that in about the time I went to law school. I graduated law school in 93, and Milkovich was about that time. And there really has been almost no movement on the constitutional front in the Supreme Court since then. And in fact, when I started law school, it was kind of a weird thing to go into defamation law because it was so quiescent. It was quiescent to the extent that I was at a talk about 15 years ago with the counsel for the New York Times, and he said he had not had a single defamation case against the Times in the United States that whole prior year, which would be unthinkable now. And we'll talk about why that is in just a second. But yeah, defamation was dead for most of my career. So when you're out there becoming a defamation expert, it's kind of like, oh, that's nice. Okay, other important reforms. The other important reforms since the 70s have mostly been statutory. One really important reform in defamation law has been anti-SLAPP statutes. A set of law professors really brought these statutes in. They started writing about developers suing people that come, protest about one of their developments at a city council meeting, and then they sue them for defamation based on that. And they're suing them just to shut them up, because here's the thing that's important to know about defamation law even today. It is very easy to sue for defamation anytime you come in for criticism, if you have a lot of money, right? The rich and powerful can easily sue for defamation. Doesn't mean they're going to win, but sometimes you don't need to win to succeed, right? Especially if you're suing somebody that doesn't have a lot of money, that's going to be intimidated, that can't afford a lawyer. It's relatively easy to sue to shut them up. And so there's a set of statutes that came out of the work of these scholars Pring and Keenan that said, you know what, we need an easy mechanism to get rid of frivolous defamation suits early so they don't intimidate people into silence. And that's what those statutes do. And they're one of the most powerful protections against defamation lawsuits in the states that have them. Not every state has one. And sometimes you see the states that don't have them or don't have a good one, like Virginia, becoming, you know, it's no accident that people like Devin Nunes have sued numerous times in Virginia, even though he's from California. Or the Depp-Heard trial, the Johnny Depp and Amber Heard trial. Again, in states that have these statutes, they end up being powerful protections against weaponized defamation suits. Now, you've probably heard about another important statute, Communications Decency Act Section 230, famously created immunity for tech platforms for defamation that originated with their users, for user-generated content. And people are now saying, well, and that really insulated the deep pocket in a lot of social media defamation lawsuits or online defamation lawsuits. People are now saying, well, big tech doesn't deserve this immunity. We need to carve back on it. The Supreme Court is considering a pair of cases that might address this, although my reading of the tea leaves is they're probably not going to carve back with these cases. They're not maybe good vehicles to do that. But nonetheless, you see here that the common law is not featuring in defamation reforms in any prominent way since 1977. That said, there's been a little creativity at the margin. For example, this is an amazing story to me. I think it would be a mark that I'm a law nerd that it's an amazing story to me. But courts, because when you sue somebody for something they say online, they often don't have money to satisfy a judgment. And also because online now you get this phenomenon of just the obsessed defamer, that they're really hard to deter because a money judgment's not going to deter them because they don't have money. So courts are now doing injunctions that you can hold people in contempt, for not shutting up after you have a judicial order. You can't keep saying that thing about the person you're obsessed with. So they're using injunctions in defamation cases as a remedy. And there also has been a resurgence. There's recent scholarship that shows that criminal libel, small fines, but nonetheless criminal libel is coming back into the fore, again, for these people that wouldn't be deterred by a money judgment. Which I think is an example of common law creativity. But we're going to talk about why common law creativity really hasn't happened. And it's partly because the Constitution has worked as a sort of practical preemption of reform. You can't go below, you have to, the constitutional law creates a floor. You can provide more protection for free expression, but the states are not free to provide more protection for reputation than they've set. And so it kind of works as a practical preemption on common law creativity. Okay, so as you probably are aware, there has, and just based on your reading of newspapers, there has been a surge in very prominent, very high-profile libel cases. So Devin Nunes has sued, I would say everybody and their dog, but it really is everybody and their cow, because he sued so many people, including a parody account called Devin Nunes' Cow. Alex Jones famously got a over $1 billion judgment against him, billion with a B. This is Nicholas Sandman. New York Times was sued by Sarah Palin. Very high-profile trial. Ended up in a verdict for the Times, but it was a narrow miss. Johnny Depp, Amber Heard. This is Jean Carroll and Trump. Trump is an interesting figure because throughout his career, he has repeatedly been both a plaintiff and a defendant in defamation lawsuits. I don't know how many. It would be an interesting thing to see how many, but it's in the 40s last time I saw the count. And then, of course, the Dominion voting system case versus Fox is very prominent at the moment. Okay. So this surge of lawsuits has corresponded with a surge of criticism of New York Times versus Sullivan and defamation law. Most famously, Trump promised to open up libel laws, and then his complaints, which, a president really can't do. That's not how presidential power works. But nonetheless, his complaints were taken up first by Justice Thomas in a kind of what most people thought at the time was a quixotic dissent on the shadow docket. It's like, I mean, I used to tell my students when we would read New York Times versus Sullivan, this is the most seminal precedent in all of First Amendment law. This case is the most famous case in all of First Amendment law. And now, you know, when Justice Thomas said, oh, we should relook at it on grounds of originalism, most of us who are media lawyers said, oh, that'll never happen. But Justice Thomas is the king of moving what's called the Overton window. The Overton window is what makes the unthinkable thinkable in public discourse. And he really, like, he starts out sounding like a voice crying out in the wilderness, but as we've seen in the Supreme Court decisions recently, he ends up winning the day by moving the Overton window. And that's what started, and now it's why we're all here today debating it. If he hadn't done that, we wouldn't be here today. He's been joined by Justice Gorsuch. But not only Thomas and Gorsuch, I mean, you've got Judge Silberman on the D.C. Circuit Court of Appeals, and now we have this new defamation reform bill in Florida that is a direct follow-on from Justice Thomas's original criticism of defamation law. So maybe we better evaluate the criticisms and see if rolling back the protections of New York Times and its progeny, because it really is not New York Times that they're angriest about. It's really the extension of New York Times to public figures, and then the whole regime dealing with cases involving private figures. So New York Times is a shorthand for the entire 30 years of constitutionalization. But we better evaluate those and see if, you know, doing something about New York Times would actually fix the problems they see in defamation law. Okay, I'm not going to spend a lot of time on Justice Thomas because his critique is mainly originalist, and Matthew Schaefer here in the audience has successfully refuted that critique. But he does have a critique about media accountability, and he says, you know, if you look at the media landscape, we've got conspiracy theories, hoaxes, campaigns of character assassination, and New York Times versus Sullivan and its progeny is why we have no media accountability. Now, Justice Gorsuch's critique on the shadow docket is a lot more nuanced, I would say. He makes what you law students will be familiar with as a changed circumstances argument, right? This is a classic legal argument that says when the circumstances change in society, maybe the rule needs to change. And so here's how his changed circumstances argument works. He says, you know, the internet's brought us a lot of good things. More people can speak, more people can participate in public discourse. But on the other hand, it's brought us a lot of bad things too. And he clearly thinks the bad things outweigh the good. So he talks about changes in the information ecosystem. He recognizes that economics have been devastating for the news media industry. And he also talks about changed professionalism initiatives. So he says, because you can't make any money anymore and the talent's been rooted out, then now journalists have no incentive to get it right. And he says, he makes a claim that's problematic, but he says the actual malice rule means they're better off sticking their head in the sand and not getting it right. I think most media lawyers in the room that's not how we think of actual malice. But he says that actual malice is almost an absolute immunity against defamation claims. Again, I would think that, you know, maybe Amber Heard would dispute that. I would think Oberlin College, that just got a big judgment against it, would dispute that. I would think Alex Jones, well, Alex Jones was he conceded on liability. It was a damages trial. But I think Fox wouldn't concede that either right now. But nonetheless, he says the overall landscape is we used to be able to rely on the media to try to get it right. And so we didn't need the law to be perfect. But now the media doesn't have any incentives to get it right. And he says the result of that is an impoverished public discourse, impoverished information quality that we as citizens have available to us, a rise of disinformation. He lays this on the doorstep of changes in the information ecosystem together with the actual malice regime of Sullivan. And then he says we have increased character assassination through the expansion, particularly of the public figure doctrine. Okay. So his prescription is we need to revisit the actual malice rule. Now, unlike Thomas, he doesn't say, oh, it's not originalist and therefore it needs to go. He said we should re-examine it. I don't read that necessarily as him saying we're automatically going to throw the whole thing out. It's just we should look at it again in light of the changed circumstances. But I do think he would narrow the public figure doctrine. And I will say that no media lawyer wants this to happen. However, if you read carefully the Supreme Court's actual cases on public figure doctrine, I think you will see that lower courts did expand that doctrine beyond what the Supreme Court originally envisioned. And if they took a case and they used the case to re-narrow the public figure doctrine, particularly in light of the fact that we can all be public figures now, it might not be as I say, no media lawyer wants this, but it might not be the end of the world, particularly because a lot of private figures will go ahead and prove actual malice, will take on the burden of proving actual malice to get the availability of wider damages, including punitive damages. Okay, but let me give you my scorecard for defamation. So we have all these criticisms of defamation. It's not doing a good job in delivering what it's supposed to deliver. So what is it supposed to deliver? Well, it's supposed to vindicate reputation. It's supposed to give you a way when you are subject to character assassination that you get your good name back through vindication and you get compensated for that. So how good a job does it do on that front? And the answer is it's not very satisfactory. And part of the reason is it's super expensive to litigate one of these claims. They drag on forever. They have especially against a mainstream media actor. They're very expensive to litigate. And at the end of the day, what most plaintiffs want is an authoritative declaration that what was said about them was false and they were wronged. And defamation law is not designed to give you that and doesn't do a very good job. Like, we just gave some examples of verdicts in defamation cases. Did any of them do that for the plaintiffs? At the end of the day, did they get an authoritative statement that, yeah, that was untrue and you were wronged? I mean, I guess the closest in the court of public opinion maybe might be the Oberlin case, or maybe the Sandy Hook parents, the magnitude of the verdict is kind of a quasi-authoritative declaration, but not really. It's not really designed for that. If it does end up compensating you, it's not in relation to your wrong. It may be in relation to fault, which is not the same thing, because it does have this doctrine of presumed damages that can be roulette-like. You know, the damages are based on the nature of the statement itself rather than any exacting figures of out-of-pocket losses. What about anchoring public discourse in truth? This is a function of defamation law. It's supposed to deter disinformation and misinformation. And the Fox News case is one that has been billed as a case to hit reset on disinformation and misinformation. Well, there's some problems with that, okay? The problem is that a lot of disinformation in society doesn't come from sources that can be deterred by this. So one thing is, a lot of the disinformation in society comes from the government, right? I mean, we're learning right now that both the Trump administration, the Biden administration, where the Twitter files revelations are showing they were running propaganda campaigns through big tech to get their view of the story out, okay? So they're not going to be deterred by defamation lawsuits. And a lot of that doesn't have to do with reputation, right? It's not targeted at individuals. It's not targeted at reputation. Defamation can't do anything about that. A lot of the disinformation comes from offshore. Those people are not deterrable. We've seen lots of other purveyors of disinformation. The disinformation problem is partly a result of hyperpartisanship, where we just believe what we want to believe. We all have our own sources, and whatever they say we believe, and whatever the other people say we don't believe at all. So we're part of the disinformation problem. We have, lawyers going out there telling stories, ethics rules, be damned. We're going to defend our client with whatever truth we want to tell. We're seeing some of that. And then we also have journalism, right? I would say, this is heresy in this location, but I would say that you know, the Fox News situation aside, where they decided not to tell the truth because their audience couldn't handle the truth, that we do have news organizations blinded by their bias to only tell one side of the story and only see one side of the story, and then ad hominem attacks on anybody who tries to bring up another point of view. So defamation law, if it's going to solve that, it's only going to solve it at a very marginal level. Now, so I would give it a D on both of these first ones. I would give defamation law a D. I'm going to be more generous on the next one. I think we get an A minus, okay? Fostering robust coverage of public officials and public figures. I think defamation law has wrought the watchdog role, especially of government officials at the highest levels. It really does a good job on that. It might do too good a job. I mean, that's Thomas's critique. And notice that Thomas and Gorsuch, I think these justices are swayed in part by what they go through in their confirmation hearings, right? They end up not liking the media very much because of how much they've been on the end of robust coverage and criticism, which is a little disturbing that they're making the policy maybe swayed unduly by their own personal experiences. But nonetheless, I'm going to give us an A minus on this one. And what about defamation law preventing the chilling effect of weaponized lawsuits? Again, I'm going to go for D, okay? And the reason is partly because actual malice is a subjective state of mind. You've got to go into the news gathering process. You've got to go into what did you know and when did you know it? We talked this morning about Fox. You've got to go into what did you know and when do you know it? When did you know it? As do each individual journalist. And then compare that to what did they know, when did they know it, and what exactly did they say on the air. And that's expensive. That's some expensive discovery to engage in. The trials are expensive. But then the worst part in my mind is presumed damages can be almost any amount. I mean, it is somewhat absurd that we are now have lawsuits either seeking or awarding multiple billions with a B of damages, okay? It's just roulette-like, it's lottery-like, it's windfall-like. And the people who win, it's not necessarily, again, proportional to the exact degree of harm. Sometimes it is, sometimes it's not. Okay, but here's the question. Okay, Gorsuch, I will say Gorsuch and Thomas are right. Something is rotten in the state of Denmark. Something is rotten in the state of defamation law. But the question is, would they fix it? And would their fix be worse than, you know, would the cure be worse than the disease? Okay, we already talked about how would carving back on actual malice, you know, significantly deter disinformation? Well, defamation law already does a little of that. Shifting to, say, a negligence rule, it might do a little more, but it's only going to be incremental. But as a social problem of public discourse, I don't think it does that much. I really don't think it does that much. Might do a little more towards media accountability. I think this morning one of our speakers said it might ultimately improve journalist reputation, but I don't think it really puts a dent in the problem to any serious degree. What about vindication? If we made it easier for people that we now call public figures to be private figures instead, would it be easier for them to get vindication? And I think that answer is no. Like I say, most of them, they go ahead and choose to prove actual malice anyway to get access to a greater degree of damages. And again, the libel trial is not very well designed to deliver that. So there's still going to be barriers to suing at all, and there's still going to be barriers to success, even if you lower the fault standard. The biggest problem is the remedies mismatch. And changing the public figure doctrine, changing actual malice is not going to do anything about that. People want, in terms of vindication, to have a court say at the end of the trial, here is my authoritative declaration. I'm going to wave my magic wand and say, you were right, they were wrong, they did not tell the truth about you, the truth is X. That's not what the trial gives. Could it give that? Maybe. In the late 80s, there was a huge foment about defamation reform. That was the last time we had a period like this. What we're experiencing now is not new. There was a huge concern about weaponized defamation. There was huge concern about media accountability. And in that period, there was a lot of remedies offered. And one was, for example, declaratory judgment that would give you an authoritative declaration that you were wronged. But on the other side, because there's a complex balance here, you have to think about, you could better help the plaintiff, but you could also better help defendants. And so if you give them a declaratory judgment, maybe you don't need the roulette-like effect of presumed damages. And so that's why I worry when Thomas and Gorsuch are looking at the problem that they're not thinking about libel bullies, okay? So they're delivering us from one problem, but delivering us into the jaws of another problem. That if you lower these standards, it's going to make it easier to weaponize the tort without much corresponding benefit for plaintiffs, and yet our public discourse really will suffer from a chilling effect on robust coverage, particularly of public officials and public figures. The other thing I think we should all think about, and this is becoming very evident, is it used to be when we were thinking about defamation, all the writing, when I started doing this 30 years ago, all the writing was about media defendants. And we mostly talked about that today. And a lot of those high-profile cases are about the media. But you know what? Any of us in this room could be media defendants now, because almost any of us, except my husband, because we use social media and we get out there, and anything you say in social media, particularly, I always tell my students, I'm going to give you one piece of advice. It's the best advice I'm going to give you. Do not use social media if you have had even one alcoholic beverage. This is the way you end your career. This is the way you get sued for defamation, is going on social media after you've had even one alcoholic beverage. But nonetheless, all of us can be defendants now. And we better hope our homeowners policies cover that. Maybe you should review your policy when you get home. You get this for free, not part of the keynote, just some free legal advice. Okay, so we really need to worry. We need the complex balance to be right. And this House Bill 991 in Florida and some of what Thomas and Gorsuch are envisioning, yes, it might benefit plaintiffs, but it may upset the balance in the way that all of us are in jeopardy. Okay, the other thing is they really have ignored the lesson of New York Times versus Sullivan. New York Times versus Sullivan, as you learned this morning, was a weaponized defamation lawsuit designed to shut down the civil rights movement. That's why the Supreme Court had to do what it did. It didn't have a choice. We talk about Sullivan as a First Amendment decision, but Sullivan was a civil rights decision. And without it, those outsider newspapers like the New York Times and the LA Times, they were lined up to be destroyed by weaponized defamation lawsuits. And so when you think about getting rid of Sullivan, you better think about the real history of Sullivan and what it delivered those newspapers from in thinking about whether you want to go back to that. Okay, so here's I'm going to try to bring some optimism, but here's the pessimistic part of my talk. Can a new restatement, right? We're redrafting the restatement. This is the time for some common law creativity, maybe. Okay, I'm going to give a caveat there. Can it untangle this Gordian knot that I've described and try to get this complex balance between reputation and free expression a little closer to something that's right? Can it help us with the disinformation problem, the media accountability problem, the reputational harms in our current cheap speech environment? The criterion for reform ought to be, you're going to simplify the complexity, you're going to modernize the tort, it's going to need to be holistic. You got to look at it holistically because you can't take on the Gordian knot, with the sword. It needs to better vindicate reputational harm, and it needs to cut out weaponization and cut out those roulette-like damages. Can it do that? Well, the short answer is only at the margins. Here's why. The nature of a restatement is to restate. It's not really a law reform project. So right now on the restatement, we're doing 50 state surveys of every single proposition within defamation law. And you can tweak at the margins. And like I say, the modernization and simplification, that's within the ambit of a restatement project. Modernizing is big, right? Taking out those references to the telegram. Thinking about what to do about ChatGPT. I hope we can talk about that on the panel this afternoon. What is ChatGPT going to do to defamation? Defamation by algorithm, already a thing, right? And so we've got to anticipate some of those problems that courts are just beginning to grapple with, and some they haven't grappled with yet, because this thing's going to be sitting around for 50 years, and you got to provide principles that might guide courts through some of the quandaries that they're sure to face going forward. But tort law is known for it's flexible, right? It's creative, it's flexible, but it's incremental. It's case by case. And tort law can't do anything about the First Amendment. Common law judges can't tell the Supreme Court, hey, you need to fix the First Amendment standards, and they can't do anything about statutes, right? So there's this complex interplay of all three, and what we really would need to get the balance really right would be something like a European, law harmonization project, where you bring all the stakeholders together and think about what the best law would look at. But you can't do holistic law through a restatement, and you can't do it through tort law standing alone. So that is one of the barriers to reform. Like I say, I still think there's room for optimism. I'll tell you, okay, Matthew Schaefer, of all the people in the room, is going to appreciate this the most, is one of the things the restatement is endeavoring to do, and they're allowed to do this, is go with a minority rule. So you can do a survey of the jurisdictions, and if only a few jurisdictions can do it, but you think it's the right rule, you can pick that rule and recommend that people go with that rule. And so it's going to sound revolutionary to those of you who know defamation law. We are going to do away with the distinction between libel and slander if our proposal is adopted. Okay? And so the reason this is so revolutionary is the distinction between libel and slander is a holdover from a jurisdictional battle between the medieval ecclesiastical courts and the manorial courts. And then there's they're like slander per se doctrine. If any of you know your technicalities, there's 4 categories of slander per se. Do you know how those came into being? Those were the ones the manorial courts would take over because they were likely to cause money harm. And the church was only going to deal with cases that caused spiritual harm. So they carved out some jurisdiction for themselves on the money harm case. And so we're trying to get that done. 200 years ago, there was a blue ribbon reform panel in England. And the blue ribbon reform panel in England recommended this 200 years ago. 200 years ago. Did they get it done? No. They did not get it done. Okay? Every court that takes up the distinction, even if they follow it, because tort law follows precedent, right? It's stare decisis. They all cast aspersions at it. They're like, oh, we know this is old holdover and old vocabulary and slander per se and libel per quad and all of that. We know this is outdated, not outmoded, and obsolete, but it's precedent. What can we do? We're just going to follow it. So we're going to see what we can do. So there's room for some optimism, but the kind of holistic reform we need is something that the law in its current complexity is really hard to deliver that, and it's especially hard to deliver that in a restatement, but we're going to do the best we can. All right, questions? Does she need a mic?
So my question has to do with, don't you think that Thomas and Gorsuch want to empower the libel bullies?
You know, it's an interesting question, Amy, but here's the thing. I think everybody lately, and this will come up in our next panel, wants to make big tech, the villain, right? The left wants to make big tech the villain, and so New York and California have statutes to make big tech censor more speech that's what they would call hate speech. So they have bills to do that. And then Florida and Texas have, on the right, have these other bills that say, don't engage in censorship of conservative voices on your platform. And there's, like I say, big tech, they're the people everybody loves to hate, kind of like the media these days, right? Which is a danger for weaponized defamation, because the media is not popular. So if you go in front of a jury, it's not good. But when they actually got the cases before the Supreme Court was like, oh, yeah, I didn't think we liked CDA Section 230, but it's kind of complicated. And what are we going to replace it with? And are these cases good vehicles to do it? And so I think they might not get rid of the entire 30 years of the New York Times and progeny regime. I think the most likely outcome would be they would carve back on public figure doctrine. And as I say, their original cases were kind of narrow on the public figure access. So I don't think they're getting rid of actual malice, but maybe I'm just an optimist.
With your emphasis on remedies, I'm wondering what you think about the prospect of a small claims court for defamation, or like a Judge Judy style arbitration thing.
I think that's a good idea, because it might actually give people more of what they want. I mean, I always tell my students, I said, the one thing you never want to do is get into a defamation claim lightly. And I bring up the example of the case of Mason versus New Yorker. And this was a rich psychotherapist of some special school who was offended by being called an intellectual gigolo by Janet Malcolm, who's an incredible journalist, dead now. And how many years did that suit go on? Was it 16? 16. So if you're the lawyer, you don't want, even if the client is rich, I don't think you want to take on a lawsuit with a client who's not in it for the money. I said, God save you from a client who says, oh, this is about the principle, it's not about the money. You want it to be about the money, so they'll make reasonable decisions.
You mentioned this a little bit, but I wonder if you can unpack a little bit more your thoughts on if one of the negative externalities of Sullivan was to halt the progress of the common law. And there are a lot of common law privileges that were obviously developed before Sullivan, some brand new privileges like the wire defense privilege, right?
Yeah.
And if the court's choice to enter the field, you suggested it's almost like a constitutional preemption if that, actually did damage to the tort.
I do wonder that. I'm a torts professor first and a First Amendment professor second. And I really adore the creativity of common law to deal with felt needs and changing circumstances. But it really did stymie a lot of what could have occurred in that realm, because it was always true that tort law had free speech concerns built into it. That's why, for example, that mere name calling is not defamatory. And it's also why the standard for determining if something is the meaning of a statement is a reasonable reader standard, not the most credulous reader, the most gullible, the most, that it has built in all of these free speech concerns and the privileges. So, for example, right now in the Fox case, there's a debate over whether this constitutional privilege called neutral reportage is applicable. The common law should have taken over the development of the neutral reportage privilege, because then it would be more developed, richer, fuller. But I think, once the 800-pound gorilla steps in, then maybe you want to back off, and that's what the common law courts have done, because they don't have much room to maneuver. And I do think that's unfortunate. Professor Henson.
Professor Lidsky, good to see you again. So, like probably one of your students and my students, I'm sitting here going, this is a stupid question. What I can't get over in my view of the world, is the absence of responsibility for actions, words, right? So my question is New York Times v. Sullivan a suit against the people who actually did the writing and the platform provider? So that as I think about, all right, who is giving people the ability to, what'd you call it, cheap speech?
Cheap speech revolution? Yeah.
Right.
Yeah. Who's giving them the ability to...
Right. So the platforms are given the ability to
Yeah.
do that. So
Yeah.
why not the platforms too?
So I will say, again, like I'm going to lose my First Amendment card for saying this. Anyway, I will say most of the world has a different regime for platform liability than we do. Okay, so we have an immunity for tech platforms, but most of the world has a regime called notice and takedown, so that we understand that at scale they can't edit and they can't decide what's defamatory, and it's really hard. And it would be unfair to impose upon them the same obligations we have traditionally imposed on newspapers. However, if they're put on notice of defamatory content, and James is probably blanching at what I'm saying, but anyway, James Dare here is probably, not, like I say, I'm going to lose my First Amendment card. But it wouldn't be the end of the world if it were a regime that's developed sensitively, because it's the regime that applies in most of the rest of the world. And so, the apocalypse would not be nigh. But it would be difficult. It would be difficult to work it out and get exactly the right balance. I mean, I think of the robber baron era a lot these days. I don't know about you, but I think back to the robber baron era. And I think about the subsidies that tort law had for the railroad industry at the beginning, and also for like in the Industrial Revolution, like worker liability for on-the-job injuries and railroad injuries. And then as the industries matured, we went to different liability regimes because they were rich enough to bear the cost that they were putting on society. And maybe at some point, big tech will have to internalize the cost that it is imposing on society in ways that arguably it's not doing now. But I don't think they're the giant villains that they're construed either. I think they're just a business trying to do their business.
All right, one more question.
Thank you. If I'm not mistaken, I think it wasn't until the 1990s that the Supreme Court held that due process could affect limitations on punitive damages in other contexts. And so that wasn't available at the time of Times versus Sullivan. And it seems to me the problem in Times versus Sullivan wasn't that the lies were beneficial in that case, but it was that the damages that were given were entirely out of proportion with the actual damage done. So in your view, if Times versus Sullivan in some theoretical world were rolled back, but the due process limitations on punitive and presumed damages were brought to bear, would the system score better on your overall report card?
Well, I think doing something to limit the lottery-like effect of punitive and presumed damages would go a long way, right, toward the chilling effect. Because the chilling effect is you don't know how high the damages could climb, and so you have to fight every case to the nth degree, because they could end up, I mean, who knows, right? It's just funny money. It's like monopoly money, and it could be anything. And so if you had some practical limitations where it would be more predictable, it also could change the settlement equation as well. If you had these different alternative remedies, it could change incentives to settle on the part of the defendants. So I think it would help. It would definitely go a long way towards helping.
All right. Well, thank you, Professor Lidsky. Very nice.